Welcome to this YouTube live session on new labor codes. Thank you for joining this. It shows your commitment to your career, to your professionalism, to gaining knowledge. Joining this on Sunday. So let's move on. I am Sharad Jain, co-founder Next Human Orbit, and with me I have my friend and guest, Mr. Nirmal Chowdhary,
Hello.
a senior HR leader who has worked in various companies. So, friends, you would be wondering, what is this session about? No, this is not a legal gyan, not a yada yada. We'll talk about practical things on ground, how to implement, how to transition from old code to new one. What are your queries as an employee, as a HR, or as a CXO, CEO, owner, MD? So we'll be answering those bubbles which are in your mind, which are bothering you. So now let's move on. First of all, can you please type in the chat from which city you are joining in so that we'll get to know each other better. The comments are open. Thank you, friends. As for these laws, earlier we had old labor laws which were framed in 1930s, 1950s. Now it's so many years gone by. With the changed economic, political, legal scenario, new things coming up, there was a need to convert all these incremental changes into a major refresh one. So it's like a restart button, consolidating all the past knowledge, all the good work done by all the governments in these past years, all the court judgments, and also providing something for the new era. So that's the thing, how it is. I can see Neha Jain, Deepti, Manish, Mayank. Thank you, friends, for typing in. So now the 29 old laws have been merged into these four codes. And can you guess the era of 1950 and now? In 1950, the value of 100 rupees, friends, today it's around 1.5 lakh rupees. And State Bank of India was giving an FD interest of 13%, 13%, way back in 1991. And you know that it hovers around 7% or so. And we expect 13% from mutual funds and stocks only. So that's how the era has changed and why there was a need to refresh, restart these things. So we'll move forward. Just to understand which all friends are there from HR fraternity, can you type HR? Those who are joining as an employee may type E, and any CXOs, founders, MDs, they can type C in the chat box. Okay, we can see friends from Bangalore also, Gurgaon also, Rohtak also, various places. Okay, great. So we'll move on. So there are various things which are there in these new labor codes. There are many things for employees. So just to recap few of them, there is a safety net for unorganized sector, gig workers, platform workers, those who are not into a formal establishment. There are minimum wages, central floor levels now, which geographical regional variations, which will be there. Then there are steep penalties for any unfair practices by the employer. Then also compulsory revision of minimum wages after every certain period. Earlier when DA was revised. Then annual leave encashment, gratuity after 1 year for FTEs, that is fixed time employees. Experience certificate, appointment letters, these are mandatory. Encouragement of enhanced savings for future. Then compulsory medical checkup above the age of 40 by ESI for certain classes, and so on and so forth. Safety officer on every 500 workers. So these are for employees. Then for employer, there is reduced paperwork, reduced registration, simplification of documentation, reduced complexity, ease of doing business. So certain threshold of 100 workers has been upgraded to 300 workers. Below that, certain compliances will not be required. And then flexi manning based on business needs, contract labors, FT hirings more easily, transition from inspection to inspection come facilitator. and flexibility in fixing work hours on daily basis and weekly basis. Then government has certain interests, promoting ease of business, encouraging women empowerment, giving justice to all the stakeholders, and reducing migration, promoting development in all the areas of the country, moving to digital India, and so on and so forth. So there is a common misconception, nothing is new for us. ऐसा नहीं है दोस्तों. Please take it seriously. This could be a dangerous assumption. And if your organization is ready in whatever role you are, HR, employee, employer, if you think your organization is ready, please type R in the chat. If it is partially ready, please type P. If it is not sure to you whether it is ready or not, please type NS. Okay, you can type in as we move on. So there are certain key changes which employees want to know. तो एम्प्लॉय ये जानना चाहते हैं कि न्यूज में आ रहा है, मीडिया में आ रहा है कि क्या हमारी इनहैंड सैलरी घट जाएगी, और दूसरा क्वेश्चन ये है कि क्या हमारा पीएफ ज्यादा कटने लग जाएगा, पीएफ डिडक्शन ज्यादा हो जाएगा. सो फ्रेंड्स, as far as your in-hand salary goes, so there are certain companies where the salary structure is already such that it is 50% already. The PF related wages, basic D, etc., they're already around 50%. So there your restructuring will not have major impact. In certain cases where it is less, yes, probably restructuring will be done for basic and other components. But some organizations follow minimum deduction for higher salary employees. For lower salary employees, yes, restructuring will impact them if organization is not transitioned already. So in lower salary cases, the impact will be there. Transition will have to be done. For salary above certain threshold as per PF norms, that threshold will not impact and it can be maintained at minimum level. A staggered transition can be done. PF deduction accordingly will move on for below threshold salary employees and above threshold salary employees. So we'll talk about this later. I'll hand it over to Mr. Nirmal Chowdhary.
Thank you. See, the number of provisions are the same as before, but the main thing is the shift in emphasis. The emphasis earlier was protecting the jobs of the workmen. Now the shift is the emphasis is on promoting productivity. So we have to see it in the light of that, a change of emphasis, which led to a number of changes, but a bulk of things remaining the same. So in the light of that, we see first there was a multiplicity of acts. Now everything has been subsumed into this four. And whilst earlier we had separate Mines Act, Factories Act, Plantations Act, and so forth, now everything has come together. So what goes for the factories will also go for the mines, will also go for the plantations, and so on and so forth. Second shift in emphasis, I'm talking about the spirit of the changes. I will come to the letters later. There is an emphasis on speed. Now, gone are the days when we used to file our returns and that had to be through registered AD and postal delays and all that. Gone are the days when we had other means of communication. Now the code is making clear that all the communications shall be in electronic or any other mode. So clear emphasis is cut the red tape or cut the postal delays or cut the transmission time and gaps. So quicker resolution, quicker information, quicker adapting to the changing scenarios. Now we know that the first cut of the codes have come. Second is all the state governments have to come out, a number of them have come out, and the rest also have to come out with their own rules, which would be in line with the central enactment. They can go a little overboard in terms of furthering the spirit of the new code. For example, if the benefits to be given to the deserving, the unserved category, for example, the gig and the platform, could be a little over than what the Central Act says, but it cannot be under because it's basically furthering the spirit of the change that has now been brought about. The second major dent is the concept of limitation. Earlier, there was no time limit about raising a dispute or raising your concern about any hardship being faced. It could be raised at any time, at any point, no matter what the delay. But now there is a clear limitation. There is a process of escalating the concern. For example, if an individual workman has got some concern relating to his employment, non-employment, term of employment, whatever, he has to go through what is now called the grievance redressal forum, which will be minimum 20 with equal participation of employer and workmen and women. Now that's an added emphasis. Clear protection of the women, clear protection of the unorganized sector. So these things have been brought about. And then no dispute or no concern regarding any hardship can be raised by any workman which is more than 1 year old. कहने का मतलब ये है कि आप 5 साल पुरानी कहानी अब नहीं उठा सकते.
तो ये तो बड़ा ही एम्प्लॉयर्स के और एचआर के लिए एक पॉजिटिव स्टेप हो गया.
पॉजिटिव स्टेप हो गया. और दूसरा है कि अगर किसी को रियल कंसर्न है तो 1 साल तक क्यों चुप बैठेगा.
बिल्कुल सही है, सही है.
तो then that has to be redressed in 30 days. For example, I'm giving you a short thumbnail sketch of how speedily the things have to go on. The grievance redressal forum has to resolve it in 30 days. If not happy with the answer of it, there's the option of going further to the conciliation officer, who again has to resolve the matter in a matter of 45 days. And if you cannot resolve it in 45 days or fails in the conciliation, there is again a channel that it can be, one can go to the tribunal. Now, again, there's a big change. Earlier, reference to the tribunal after the failure of conciliation at the point of the conciliation officer was done by the government. Now it's open to any aggrieved party to appeal to the tribunal for adjudication of the grievances. So we see there's a very quick-paced delivery of justice. So that's a change of emphasis. The process may appear apparently to be the same, escalating level by level, but the change of emphasis, quickness, no dilly-dallying. If you've got a real problem, you have to speak up within 1 year, and then the person that you refer the matter to has a given timeline. He cannot sit on the matter with hearings after hearings and so forth. So
यानी जिसको कहते थे कि justice delayed is justice denied.
Denied.
So that has been put into action.
And a major dent has been made. The concept of limitation, which never existed since the time of our legislations that are around the era of independence and some even before that.
Yeah, British era also.
British era also. Now, if India is to compete amongst all the nations on a global level, we have to roll up our sleeves, and that is what the courts intend to bring about. Because plain protecting of the jobs was good enough when India had indigenous production for indigenous consumption.
So I can see some questions in the chat box. Mr. Manish is asking something. So we'll definitely take question answer towards the end of the session around 12 o'clock. Just give us some minutes so that we can complete the main flow. Thank you.
Then again, we see the penalties for violations of the rules. They have been simultaneously made hard and made soft. Hard in terms of the quantum of fines, which were very small in the earlier laws. Now for violations of, for example, in the matter of unfair labor practices. For the second offense, it can go as high as 4 lakhs or thereabouts. And another major change, gone are the days when only the employer used to be penalized. Now the penalties have been clearly spelled out, and not only are the employers to be penalized, but equal penalty. Mind you, no softening of the penalty. Equal penalty if there is a omission or commission amounting to unfair labor practice on the part of the worker. Again, a change of emphasis. Earlier, we used to talk in terms of workmen. Now we are talking in terms of worker.
In fact, penalty say like in OSH code, there is a highest penalty of 5 lakh rupees also. So that is unimaginable in the past era.
Unimaginable, and further, I said there's been a simultaneous harshness and softness brought about. For example, there used to be the sentences of imprisonment in a number of matters. Now, as far as the IR Act is concerned, even a sentence of imprisonment is compoundable. That is, if unwittingly you have done something, mind you, it's the first offense, unwittingly, because these laws, this code, and the rules are new, there might be occasion when, without the least of ill intent, unwittingly, someone might run foul of these rules. So, in such cases, people are not to be unduly penalized. Hence, a concept, again, a new emphasis, compounding. The concept of compounding has been brought about very judiciously, inasmuch as in the IR code, compounding of prison sentences is possible by way of paying 75% of the highest penalty. And as far as fines go by paying 50% of the highest penalty. But the question of compounding of the imprisonment sentences in the occupational safety does not arise, because there the stakes are very high. We are talking about safety, health, and environment of the people working. That cannot be compromised. Since that cannot be compromised, prison sentences there are non-compoundable. Whereas when it's a matter of procedure, no human life or property is at stake. Some procedures have been flouted unwittingly. First offense. There is a provision of compounding the same.
Nirmal ji, I am getting some offline messages that people want to know. There is a lot of talk about working hours, shifts of 12 hours, changes in overtime cost, and then some impact of wage definition changes on PF, gratuity, CTC restructuring.
I'm about to approach, I'll touch upon each of these concerns, and very valid. These questions are very valid, and they are truly agitating the minds of the professionals in the HR field.
HR also and owners also.
Owners also.
Right. Business ka बढ़ तो नहीं जाएगा.
Right. So, as has been said, but before I get to that, I wish to say there is a big, and you can write in capital letters BIG, major shift in emphasis as far as the employment of contract laborers go. So here, a bit of reading between the lines is needed, but the biggest emphasis is earlier, the contractors were officially given the task of producing a given result for the principal employer. They were not supposed to be mere suppliers of manpower as a mere human resource. But now this code makes it clear that the contractor can do two things, one of two things. He can either undertake to produce a given result for the employer, or, and this is new, he can supply human beings as a mere resource, which was not so earlier. So that leads to, which has not been specifically said in the code, and this is my my reading of it between the lines. And before I say this, I stand open to correction in the light of uh, people with deeper knowledge. I stand subject to correction if I say this.
In fact,
This
in
is
the
my
definition, you are right.
no,
In
no,
the definition they have given, manpower can be supplied,
supply, but then
which was
that,
earlier never there.
never there. But that leads to one inference on my part, which I venture to put forth, subject to correction, because this is only my inference, that earlier there was this big concept of supervision, and supervision by the principal employer was not allowed because the contractor was not supposed to supply mere manpower. I send these people to you within your premises, and then you ask them to do what they have to do. And you, with the supervisor of the work they put out in terms of quantity and quality. But now, if as per the letter of the code, I am also free as a contractor to supply you manpower as a mere human resource, it is my inference, humble inference, subject to correction if I am wrong by people who have more knowledge about this. There seems to be some kind of relaxation in terms of supervision by principal employer. But again, I take ownership for my own inference. It is not part of the statute or part of the code, but it seems to me that this is a natural corollary. Because how else can this be explained?
Absolutely. In fact, I had attended long back around post-COVID times, large session conducted by a big organization on these new labor codes. So there were 4 Sundays dedicated to each code. So there also this value-added point, which is of interest for HR and employers, did not come up. But yes, in the code it is clearly written that results as well as manpower supply can be done. So earlier, lot of time was spent by HR employers in getting the license, what to write in the scope of activities, and lawyers and retainers used to suggest. मैं खुद कई बार मिलके आया था कोई complex cases में. So they used to say कि it should not appear as a sham contract.
Again, this code also says, whilst on the one, see, it's a situation where it's an either-or situation. They are saying they're allowing flexibility as well as, on the other hand, imposing a certain degree of rigidity. Here, in this context, whilst on the one hand, he has allowed that manpower may be supplied, yet on the other, there is an equal talk with great emphasis on the concept of prohibition of labor on core activities, on process work, on perennial work, or where long employment of labor could amount to denial of permanent job to the workman. So it is a very balanced, even-handed approach. It should be interesting to see how the rules that come out afterwards handle this tricky issue, because there is a yes, you are allowed, but subject to. So it's a very fine balance has been struck between empowerment and due constraints,
Right.
as far as this goes. Now, you raise certain concerns from people.
Yeah, what is
Wages, you said,
working
no?
hours, overtime, 12 hours, 8
Yeah,
hours,
yeah.
all these
Working
things.
hours, a good deal of flexibility has been given. Earlier, the Factories Act was overprotective of people. So there was this concept in the Factories Act that you could only have certain number of hours per day. After every 5 hours, you should give at least half an hour's break, which is still there. But then the Factories Act earlier said that you could not exact more than 48 hours of work from one individual. Anything in addition to that had to have overtime, subject to the cap that the total number of working hours, I'm talking of the central enactment, I'm not talking of each state rule, subject to the fact that one working week comprising the working hours plus the overtime could not exceed 60 hours, subject further to the proviso that in each quarter the number of overtime hours could not exceed 50.
Which has not been increased already, maybe to 125 hours.
Now, a
For
good deal of flexibility has been brought about, saying that you could have 4 days a week, fine, if the nature of your work demands. You could have 6 days a week, fine. Only 1 day of leave has to be given, weekly rest. But then a good deal of flexibility has been given that you can up to 12 hours per day on a spread over basis. You could have, it could be 4 days, but the total number of working hours should not exceed 48, which remains. Anything over and beyond that has to have overtime at double the ordinary rate of wages, which remains. And here, when the double of ordinary rate of pay, sorry, not wage, pay. So the very word suggests that you have to include the allowances as well. Because see, another big change, the definition of wage. The definition of wage has been cast in a manner which says only the fixed element, the variable element, and the retiral elements. Now, wage has been classified into three broad categories. The PF bearing fixed element, which speaks about the basic, the DNS allowance, and the retaining allowance, if any. That is called wage, and the rest is not called wage, which is the variable element. It could be paid on a given month, it could not be paid. It could be in terms of overtime, it could be in terms of commission, it could be in terms of
conveyance
allowance and so forth, which might or might not be paid each month. So it is not fixed. So the fixed component is PF bearing, on which your returns would be computed, but the rest is not PF bearing, on which your ESI would now also be computed. The rest is not PF bearing, but it is variable. And third, the returns, by which is meant the gratuity and the retrenchment compensation. So nothing beyond your basic DI and retaining allowance is now to be wage. But mind you, the same does not necessarily hold true as far the computation of overtime wage goes.
So essentially, for our audience, just to consolidate what we discussed, the working hours remain 48 hours a week at maximum. However, the shifts could be 8 hours also and 12 hours also, 10 hours also. There is a flexibility between the window of 8 to 12 hours per day. And if the shift itself is 12 hours per day, depending on your working requirement, business needs. So working in a single day up to 12 hours will not be counted as an overtime. So that's a big flexibility and win-win situation, because total cap remains for a weekly basis of 48 hours. So like IT was already working 5 days a week. There were certain sectors where due to business fluctuation, peak demand, less demand, there was a need that factories were shut down during certain days. So that variation in business needs can be now catered through legal route. That's the take. And wages definition across all the acts were different at times earlier. Now it has been unified across all the codes. So wage definition remains same. So that's a good standardization and simplicity.
That is also a necessity, because when you have combined all the acts, subsumed them into the same code, having common registration and common returns. Now with common registration and common returns, how can it be that you have different definition of wages? It would crisscross and clash.
It was crisscrossing earlier also, like in Payment of Wages Act, Minimum Wages Act, there was some definition, in Factories Act there was some, and so on and so forth. So that's a good simplicity which has been done.
I'm sorry to come back to the point of contractor. Now the contractors, it seems, from the reading of the code, will not be given any PF code or an ESI code. The code shall have to be necessarily by the employer. This is a big change.
So there are some additional questions from Mr. Sharad Sharma, and we'll be happy to answer all the questions in the chat box. You can type in as and when it comes to your mind. We'll be taking all the answers towards the end of the session. Thank you for your patience. Yeah, please, Chowdhary sir.
Yeah, the PF and the ESI acts will remain for some time as they were. They may undergo some change, but as of now, There is to be no change in the threshold limits of provident fund. That remains at 15,000, and the threshold limit of ESI that remains at 21,000. But going forward, it should be interesting to see what happens. So there has been a look and see period as far as this goes, and these stay. These limits stay for the time being. But there is an interesting, very interesting thing to observe, that people who had gone out of ESI coverage might well come back into ESI coverage by virtue of definition. Yes,
Definition.
recasting the cost to company in light of the definition of wages. See, earlier in ESI, all the components of the monthly payout of the concerned individual were included in determining the contribution thereon from the employer and the employer side as far the ESI goes. But now it has been compressed into the wage only, not the allowances. So there is a good deal of possibility the people who on account of inclusion of allowances into the wages had gone out of the threshold of ESI, now because of the compression of the definition of wages, might well come back into the coverage of ESI.
So that means that all our friends of HR, IR, or the employers or MD office people participating here, so they will have to take a strategy call, if not taken already, that in the transition period. So there is no categorical transition period given in the code. However, informally, it is being anticipated that probably it will fully transition by March end, March 26, because the state rules, most of the states are drafted already. So they will just activate them, get it finalized, get it signed off from their respective machinery, and more clarity will be there for grassroots implementation in all the states. So practically, I guess by March, all implementation will have to be properly in place. All the strategic decision by HR, employers, leadership, CXOs, they will have to conclude by January, and that's a hunch, if not done already. So all the wage restructuring, particularly for the lower threshold wages, all the workers, employees below the threshold, so they will have to be meticulously done, considering all around impacts on various cost structures, benefits structure, welfare, and any potential conflicts or IR scenarios arising out of it. And then communicate, take your leadership along, and then deploy it. So we'll move forward.
In fact, I might add one point. There is a possibility. It is nowhere. It doesn't come out in so many words. There is a possibility of reviewing using artificial intelligence, reviewing the revenue coming by way of PF, ESI, and cross-linking with other returns. There seems to be a possibility going forward.
ये तो हो ही सकता है कि
And
जैसे
as far as the recasting of the wages and so forth,
correct,
because the financial angle is there, that seems to be a possibility.
Correct. So I think government is trying to go digital, make life easy also for employers and HR and employees, as well as make the compliance part smoother and less inspector driven, more system driven. So जैसे इनकम टैक्स में बहुत जमाने पहले, मतलब आई रिमेम्बर 1996 में मैंने पैन कार्ड बनवाया था, तो तब मैंडेटरी नहीं होता था. धीरे 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 अब तो हर चीज के लिए मैंडेटरी हो गया. एंड नाउ इन इनकम टैक्स रिटर्न वी कैन सी फ्रॉम आवर लॉगिन कि पूरे साल भर में हमारा क्या ट्रांजैक्शन हुआ थ्रू AIS एंड TIS. तो हमें भूल जाता है कि हमने क्या क्या किया था, लेकिन वो सब उसमें
नहीं, अब तो मुझे ये लग रहा है गिग और प्लेटफॉर्म वालों का भी आधार और बैंक अकाउंट सब लिंक हो जाएगा.
बिल्कुल. So that's a big changes which are happening now, and we all need to be prepared in case we have not already or we are halfway through. So I think based on what discussion we just had,
there is one major angle, the trade union angle.
वो तो रह गया. जिनके यहाँ भी यूनियन है, they will be interested to know.
Now trade unions, the biggest trouble with trade unions was the multiplicity. And very small unions forming their own body and getting registered, and that led to politicization, number one, infructuous multiplicity of unions, which did not really give real benefit to the needy. So now, as against the earlier provision, where only 7 people could come together and form a union, so now a big dent is a union means a union. A union doesn't mean 7 people shaking hands and taking on the garb of a union, unable to generate funds, unable to do any good to the real workman, real worker who is in need. So if you are forming a union, by golly, you have to act like a union. To that end, now this provision has come out that you have to have 10% or minimum 100 in order to form a union. And again, the concept of negotiating union. You have to have clear majority, 51%. If it is not possible in a given establishment for a certain union to have 51%, the alternate provision there is a number of unions come together, each having no fewer than 20%. And they form a negotiating council.
A consortium sort of.
Consortium sort of. So look at the advantage. Unions are strong, they win business. So if you're going to run a union, gosh, no fooling.
You are accountable.
You are accountable, you are answerable, you have to deliver the goods to the workmen, and you have to act in good faith, like a union, number one. Number two, the splinter groups saying, the small splinter groups cropping up, mushrooming throughout the industry, and saying, we don't agree to what has been agreed to by the main union, and raising their own demands, has been put a lid on. So now, fine, if there is not one union that has got a clear majority and there is a consortium, as you say, of negotiating unions, as a consortium, they are answerable to the final decision, to the final bargaining, collective bargaining that takes place. So there is a uniformity in application of the settlement.
So union बनाने के लिए कोई union नहीं बना सकता. You have to be serious enough to form a union.
You have to mean business as a union. You have to mean business as a union. So that's a big takeaway here. Then again, there will be no labor codes going forward. The concept of labor codes has been given a big go by. Tata bye bye. Even in the IR code, there is also a provision that says the pending cases in the labor courts shall henceforth be given over to the tribunals. So it's all in the interest of delivering speedy justice without delays, and the whole ambience is about meaning business, because we have to promote productivity and be competitive on a global level. Yes, right. You are adding a point.
Yeah. So I am saying that in the interest of time, certain indexes we'll cover towards the end if time permits. And there is a chat that how should implementation be done, prepared. So we had planned certain things already towards the end and certain things in between. As far as mini checklist is concerned, so maybe one, the HR and employers can review the attendance system, wage structure review, policy documentation for wages, compensation structure, PF, gratuity, in-hand salary components, considering employees' comfort, discomfort, short-term benefit, long-term benefit. Because younger people need more in-hand salary, and as we move towards 40s, 50s, then there is concern for better retirement fund, better savings. So HR employers always keep balancing between the different age groups in the organization. So that exercise will need to be done. Then shop floor discipline, unfair labor practices, penalty, standing order. So these will need to be reviewed, particularly in manufacturing sector. And like sales promotion, employees have also come under the ambit of this based on the salary threshold and other thing. So because Sales Promotion Act has been come into this code also. Then taking managers, supervisors along, leadership along, creating awareness in them about the changes, and steering the entire change management in the organization. So that's a big need as a mini checklist to talk at this point of time, and we'll be happy to provide a little more detailed checklist for transition implementation. Those who need that, they can type in their email ID in the comment box and just write checklist. We'll be happy to share them on their email IDs. It's a free service to the industry. Now, uh, coming to further points with respect to the MSMEs, the promoters, the CEOs, CXOs, and leadership. So they are more interested in risk management, cost control, and any kind of penalty exposure changes, which Nirmalji was already talking about. So yes, in terms of penalty exposure, earlier there was imprisonment even on smaller issues and findings. Now the overall shift is that from criminal kind of mindset
Criminal intent versus procedural lapse.
versus procedural lapse. So government says for minor issues, some mistakes in register, something here or there is no imprisonment. You just pay certain penalties, certain financial implication is there. Then for severe offences
With
like
criminal intent.
with criminal intent or
Or,
serious
or
lapse,
criminal, I will not
Serious
use the word
lapse.
intent,
Yeah.
criminal neglect.
criminal neglect or
Criminal
serious lapse.
neglect.
Yeah. For example, there is a injury which leads to death in some premises, or there is a major safety accident like that. So that is considered as a major neglect or a repeat offense. So in that cases, fines also go up into lakhs of rupees, as well as imprisonment also can happen. Jail can also happen along with fines, or jail will happen. So that's a deterrent. Obviously, it was there earlier also, now also. Only prioritization has happened. Like
But
if,
since these there's all these laws and rules that will come are totally new, the government has also changed the nature of work of the inspectors.
yeah,
They are to guide you towards better compliances.
true.
So they cannot only be there to find faults with what you are doing. So they have been given a twin responsibility, rights and duties.
Correct.
Their duty is to
Facilitate.
facilitate. And
So yes, the term has been used, inspector cum facilitator. That's a conscious term, and words have their power and meaning associated. So from inspector to inspector cum facilitator. So coming,
may I add one,
Yeah, please.
one very vital point, which was never there earlier in the central enactment. I recall in Maharashtra, the local laws enacted by the state had this provision, which has now been brought into the central enactment by way of this IR code. The tribunals have been vested with the powers of granting interim relief. In the Maharashtra Act, it was interim relief amounting to total relief. I don't know whether that is there or not, because that has not been said. But this code says the tribunal shall have the power, because it's genuine. For example, a worker is badly aggrieved. He is suffering innumerable hardships. Now, you cannot ask him to wait till the end of the litigation and continuing to suffer till one outcome, one or the other comes. So earlier, this freedom was not there with the tribunals to grant grant relief prior to adjudication, which has now been brought about in this new code.
right. So so since there are many things which are on cost, on risk, on compliance, transition. So the risk management is important, and I suggest all the promoters, owner, SMEs, CXOs that don't just outsource this thinking to pure HR or pure legal consultants. You have to get involved to take a strategy call on various aspects. There could be cost surprises in case you don't deliberate properly. One is overtime, because wages structure, CTC structure, salary structure were quite different in different companies, different cities, based on their own business sectors cost structures.
Now it will be tricky.
Now we will have to transition for sure, and in that process, uh, as per code, as per the central code, we don't see that there is a intent to increase the overtime cost. That is what we can say on this public platform. The intent is to keep a win-win situation between the employees and the employers. So the code per se, in terms of intent, doesn't seem to increase the overtime cost. However, uh, the definition have changed, and one big thing is that the wages on which, let's say, the PF deduction sort of happens for those below the threshold, and otherwise also it has to be 50% of the total baskets. So due to this transition, when you calculate the overtime, this cost may be different. So you'll have to spend a lot of critical thinking on this. Then PF alignment, yes, has to be done. Gratuity calculation has to be done, and gratuity in most of the cases, because normally industry used to keep lesser basic wages, compared to the overall thing in the pre-COVID eras, and until this
High on allowances, low on basic.
And until the time this Surya Roshni judgment came. So that was the big judgment which facilitated from Supreme Court transition towards this 50% kind of thing and PF changes. So
that was basically the trigger that brought about this change.
Entire thing. So gratuity cost may also go up depending on your structure, and so depending on your context, your sector, your specific company, your specific structure for various employees and workers, we would say that compliance at times may be cheaper than going for penalties or violation. So we'll have to see on a case-to-case basis, and any kind of detailed inputs we can give only on a one-to-one basis to those interested. So as a CXO leaders, I saw in the chat that some participants were representing MD office, or they were owners, promoters. So can you just type in the chat, what worries you more, the cost or the complexity? So in word, please type what concerns you more, whether as employer or even the HR fraternity, the cost or the complexity. Please type in the chat. So now, Nirmalji, I think we are already at around 11:48. I will suggest you cover this employee and worker perspective also. What are the key changes for individuals?
Yeah. See, there was an earlier impression that the labor laws per se concerned the workers only, which was not necessarily so. But by and large, it was so. But this code, for example, the Factories Act included many people. Anyone who was concerned with the manufacturing process, whether he was a worker or a supervisor or an officer, was covered by the term worker in the Factories Act. But now this code, since it is subsuming so many disparate enactments into one, here they have used two terms. One is employee, which could also include the supervisory and the managerial and the administrative staff, whereas the term worker, by and large, relates to those who are doing work which is unskilled, skilled, manual, technical, operational, supervisory, clerical, and so forth. So that is the key distinction. As soon as you use the word employee, the canvas is wider, but as soon as you use the word worker, your canvas narrows down to these categories.
So one is that wage definition is now common for all, be it white collar employees, be it blue collar workers. Second, overtime. So overtime as an industry practice was extended mainly to the blue collar category. So those practicalities will remain almost same without much changes. Those who are coming in shifts and other aspects. One relevant point at this point of time is that there was a perception that IT employees cannot form unions. They cannot be counted as workers per se. But even in the previous laws, there have been many IT unions formed already, registered legally in South and West India. So IT employees have already formed trade unions, so to say, and they have been fighting against unfair practices of employers of IT companies. So by definition, in multiple sector, depending on the job role, that plethora of thing has opened up already, even with the previous laws. And in the new code, with increased awareness, because things are consolidating. So even in the communication by Government of India in press releases, they have talked about benefits for the IT workers. For example, salary by 7th of the month. So we have
So
to
this
be cognizant.
myth has been busted.
Yes, it has been busted, and HR and employees will have to be more cognizant of various things coming up new, which was not planned, but it will come up as a unplanned and surprise things also. So I think since we have moved to around 11:15, so we'll focus now on certain myths which are there, and then we'll move to the question answer section. So one myth is that smaller companies are exempt from any compliances and they can work freely if they are below 300. So we'll talk on this. So Nirmalji, very quick snapshot answer for the audience. Is it true or wrong?
It is false.
And why so?
Number one, the Act also covers the companies that are below the threshold limit of 300 workers. So there is no question of they being exempt. Only the quantum of restrictions and the quantum of punishments, if your organization or your establishment is having 300 or more workers, goes up. Sorry. But there is no question of exemption of those who are having fewer headcount. So it is again a myth.
So yes, there are different threshold even in new codes for different things. For example, for occupational safety and health, the factories with power, without power, the threshold has been increased to 20 and 40. The contract labor deployment for that threshold is, for registration is 50. This 300 limit is only for certain matters, not taking permissions from government for retrenchment of workers like that. So otherwise there are threshold, and for certain things, even those below number of 10 employees, they will also have to do certain compliances. May not be registration, but certain procedural things are there. So we'll have to study everything in detail and not take it for granted. Myth number 2, these codes apply only to factories. So Nirmalji, what do you say?
No. Again, it's the answer is a clear no. It applies to all manner of industrial establishment. And when we say the word industrial establishment, it includes any manner of, if it is an industry where the employees and the employers are coming together and in coordination producing goods and services for the satisfaction of human wants and needs. It is as broad as that. Then it is an industry. And whichever establishment is falling under the ambit of industrial establishment is covered under the code.
In fact, long back in the days of old laws, many institutions used to think that they are not part of industry. For example, schools. So there was a landmark Bangalore Bangalore Water Works case, which gave a refined understanding of the word industry, and not lot many institutions like schools, they came under the ambit of Industrial Dispute Act and under the term industry. Similarly, in new course, the word establishment, it takes cognizance of many kind of
But they have been clear about certain exemptions. For example, if it is a religious or charitable organization, that will not be within the ambit. If it is a research-driven organization, that shall not be within the ambit. If it is for medical research and all that, there are a number of classifications. So, which basically are not
so commercially oriented,
which are basically not producing goods and services. But there is a coordination of
activities and processes.
So they have been kept out of this ambit.
So a lot of wisdom has been applied in applying discretion, where to apply, where not to apply. But yes, there should not be any myth around that it is applicable only to manufacturing of factories. Third, that myth is there that cost will get impacted by overtime rules. In fact, there was a question also, I guess, from Mr. Manish probably will see again in the chat. So, Nirmalji, what do you say about this? Cost will get impacted by overtime rules in new code.
It may not necessarily be so because it may not necessarily be so. How can it be so? Because the overtime you have been paying earlier in no manner has been the per hour implication, financial implication enhanced.
So, in fact, earlier also there was a notion that certain companies used to think that overtime can be paid on a single rate or double rate at certain components. So it was double the ordinary wages earlier also, and it is double the normal wages now also. Only thing is that components have been standardized, restructured, and as far as we have interpreted it multiple times, the central code does not have an intent to increase that and making unfriendly to the businesses. However, due to this 50% clause in the wage definition,
it is only putting a ban on playing with the costing of the package, whereby the PF bearing emolument and which adds to the long term welfare corpus
Welfare of the employee.
corpus employee, that cannot be shrunken to an insignificant degree.
So that is a trade-off. Government wants welfare of the employees in the long term towards old age when the employee retires, versus at times younger employees want more in hand and lesser savings in the initial years. So that's a trade-off. We'll have to see how it pans out. But yes, in terms of intent of the code, it does not intend to increase overtime per se, but due to wage restructuring in certain companies, in certain sector, depending on your current structure, it may get impacted somewhat.
There's been a clear attempt to strike a very judicious balance between the interest of all stakeholders, the employees, the employers, and the government. When I say government, I mean the country in terms of being competitive globally.
Yes.
So, but how it works out, there might be some teething trouble, there might be some glitches further down the road, which will be addressed, I'm certain. But as of now, the intent seems to be very robust and very healthy.
True. So in fact, earlier we had era of only Ambassador and Fiat making cars in India, and now we see that more than 20s of manufacturers entered India. Some of them even closed down, like General Motors. So that's a era of open competition, global import export, so many things. So one is talking within the country about employers, about employees. Second is taking the competition also, which is coming from across the globe, like from China and other countries. And so that is also being taken care in this code. And everyone will have to remain competitive, the employees as well as the employers. Another myth is that contractors will take care of compliances for workers, which are deployed in the premises for own work.
No, here I beg to disagree. The entire onus of ensuring that compliances are made have, I wouldn't use the word have, but seem to be cast on the employers.
So who will have to deposit the PF for the contract workers?
The very fact that the PF code, it seems, will not be granted to the contractors, will only be granted to the principal employers, leads us to infer that the basic onus of compliances shall now rest squarely. It may be done through the contractors, by the contractors themselves, but the onus of supervision that it's done and being answerable to the government that it's been done by the contractors rests, it seems, from the reading of the code, it seems to rest on the shoulders of the
principal employer.
Yeah.
Okay. Now, since we are approaching around 12 o'clock, so we are now open for the questions in the comment chat. Some questions have been asked in the chat box already. We'll be taking up that one by one. And any additional questions can be typed in the chat box. And we are sharing our email and mobile number in the chat so that anyone who wants to contact us for any further clarification or a deeper kind of consultation, one-to-one discussion,
yeah.
consultation. So we'll be open to that. info@nexthumanorbit.com. This is our mail ID. And mobile number also we are sharing, which is a WhatsApp number. You can contact on WhatsApp, because at times we may be having our mobile on flight mode when in a session, but you will be reachable on WhatsApp also, and we'll respond and get back. So anyone who wants the checklist may please share your email ID and type checklist in the chat box. So we'll start taking the questions. So first question was from Mr. Manish. So time frame for grievances, change of mindset needs to be from employer point of view. Things, evidences must be in place at right time. Nirmalji, you like to add anything beyond what has already been said?
What is the focus of the question?
I think the one is the time frame for grievances. There is a timeline
Yes,
for
clear
employees
clear
as well
time.
as the
Yes,
government bodies
yes,
for
yes.
all steps.
Yeah.
And yes, there needs to be a change of mindset in employer and HR.
Yes.
That has to be there, and evidences must be in place at right time.
True.
So yes,
you can't miss the bus.
as soon as any grievance arises, any conflict arises, the employer and HR should start initiating the inquiry process, collecting the evidences, all those things. And for employees, there is a cutoff window also, that after certain timeline they cannot raise any grievances. So that's a good thing. But once it has been raised, then we should act
We have
on
to move speedily along.
Speedily. Then will existing settlements and arrangements remain valid after implementation of new codes? From Mr. Sharad Sharma.
Yes, they will.
They will remain valid. So in fact, during this transition period, we have to comply the older laws, and as and when the portals will change, the forms will change, the rules will come into picture, then transition time will be given officially, I am sure, and then transition will have to be done and moving to the new platforms, new portals, new registers, forms, etc. Another question, also brief the F&F settlement within 2 days concept as per new codes.
Yes, there is a provision that within 2 days it has to be settled, including in the case of voluntary retirement.
So yes, that means indirectly digitization of HR systems.
See, a person cannot be put to hardship just because he has left the organization or has been asked to leave the organization.
Sure.
So, in order to, and it's very fair that if the man is going out of your organization, he has to be settled within.
Sure. So earlier, after resignation or termination or whatever, typically in some companies, the full and final check was given on the last day of the service. We have seen that in one of our past organizations. So even retirement or other things, the checks were given on the same day or on the next day maximum. But now it is a mandate that within 2 days, full and final settlement has to be done mandatorily, legally. Records will have to be there. So I think once the HR system are already there on digital platforms, those companies who are still doing it manually, they will have to migrate soon to some digital platform for these calculations.
You cannot now say that you are leaving this organization on the 10th, but you have to wait till the 7th of the following month to get it.
Not even that. At times, employees used to follow up after months also. What happened?
So that is too harsh.
So now this facility is available for all category of employees. Another question is, how should organization prepare for implementation? So some mini points we have already spoken during the session, and all those who will be sharing their email IDs will be mailing them the broader checklist. Another question is from Mr. Manish, views on overtime as per new codes. Is there change in definition and its calculation? Please address during Q&A. So I think
he can take it up offline.
Yeah, one is that in general, whatever can be shared on public platform that we have already shared, there are certain things which cannot be spoken on a public platform, and so you can reach us on our
all above board though.
Yeah.
But in fact, the particular circumstances of your situation have to be understood before
yes,
you can.
The context has to be understood. Another question is, are inter-strand migrant workers required to register
No, they have been subsumed in the act.
in the act? So there was a separate Migrant Labor Act that has been included in these codes. Another question from Mr. Mayank: there is provision of national minimum wages. How much is it's expected? Will it increase cost for states with lower minimum wages, even if central government keeps it average of India currently? So, Mr. Mayank, I would like to say that there is a provision in the code of regional geographical floor wages. So, although the current notion about the code is that there will be a national floor level wage which is applicable from northeast to west to north to south India. However, in the final lines in the codes, what we have studied, there will be provision for regional geographic variations on the floor wages also from central side.
See, the cost of living in Sikkim can never be the cost of living in Mumbai.
Absolutely, absolutely. So this floor wages is to protect the quality of living, minimum standard of living for all the humans living in different parts of India. So this will take care of cost of living required for a common kind of quality of life, but it will not be same value in different parts of the country, and that's the leeway how central and state and quality of life of humans have been balanced out. Another question: it will increase cost for companies in below national rates states and make them uncompetitive. So yes, as we have discussed already, it will consider regional geographic variations of cost of living.
Will be judicious.
It will be judicious. So it will prevent any exploitation of or any citizen of the country living into a very different kind of quality of life versus some citizens enjoying say lavish life. So it is just to take the bottom of the pyramid towards upward, not to make the employers cost competitiveness going away. Then yeah, so I see that some people are bothered about complexity and any change in reporting like returns as far as overtime. If so, it will change mindset to deal with it in real corporate life. So in terms of reporting, Nirmalji, I think there will be now.
We see it will be too premature to talk about that because the formats and all that have yet to come out.
Yeah.
So a clear view can only be given once they come out. But by and large, there is a move towards simplification. There's a move towards simplification, not a move towards complexity. By and large.
Yeah. So the registers, the formats, the portals, they will be coming up in reality when state get their rules approved, which are in draft stage for most of the states. Only two states sometime back, like Gujarat and one more, they had finalized their draft rules on certain codes, and they are now not in draft; they are final version. But rest, when all the states come up with their own things, form formats, registers, etc., so then clear picture will emerge within few weeks and months in various states, and then the true implementation on the ground will actually start happening.
But I see no cause for fear.
Yeah.
As far as complexity goes.
Complexity, we are sure after reading all these codes that it will reduce. It will not go up, it will reduce. Probably the last question in the chat box. If any change in salary structures post labor code, then employer needs to revise all appointment letters, agreements, or just release amendments. Does that mean as HR we need to revisit all existing formats?
Letters need not be given again, but the recasting of the remuneration has to be done.
So again, this will be on case-to-case basis. If your current salary structure for various classes of employees, which are under the legal threshold ambit, and those who are out of it, so if that is complying to the new code also, you need not do restructuring. In case you have to do, then yes, a communication about that will need to be given to the employees. They will need to be taken in confidence. More than the letter, taking the employees into confidence in case their in-hand salary is getting impacted, that is more important. And yes, the terms and condition once revised, so for avoiding any legal complication, it will be better if you reissue the revised structures like we give after the increments for transparency. So something like that can be arranged. One question from Disha. Currently, we have practice of offering default PF deduction of rupees 1800 for all new joiner staff. Those who request to deduct PF on actual basic, we do for them. Can we keep same practice continue?
Yes, if that has been the practice in your organization, you can keep it because in this code there is no mention of raising the threshold. The threshold remains the same. So if you have already been giving on full salary, of course you can't go back now.
Yeah.
But if you have already been, if you have in the past being given the provident fund contribution only on the minimum threshold, then there is no compulsion to increase it.
Correct. In fact, in our past organization, so I was working in a larger organization, about 30,000 crore. So there, all employees had good salaries. So all were getting PF deducted on actual basic, 12% on entire basic, and some were going for voluntary PF also over and above the minimum one. Whereas in some of my past organization, like a smaller organization, so their salary structures were different, particularly for entry level employees, mid level employees. So they wanted higher end salary. So to remain competitive in the industry, there was a practice that those employees who were out of this threshold basket of PF mandatory requirement, so they got a PF contribution on this minimum 1800 based on the threshold limit. And after joining, if employee used to ask for actual basic based PF deduction to build in for the retirement kitty, PF kitty, then that restructuring was done for that employee at the CTC fitment stage or post joining also. That request was accommodated. So yes, this practice can be there. It is legally compliant practice. Lot of HR portals, HR software systems. I implemented one in my last organization. So they have a provision for actual basic and PF basic. So two basics can be treated in most of the good level of HR softwares, digital solutions. So this practice can continue to remain competitive into hiring based on the industry and needs of the employees. Yes, that's possible. So I see that all the questions have been answered in the chat. Welcome Disha and welcome Mr. Manish. Another question from Mr. Mukesh. Okay, is there a need for education to the employees that this is a must for you for your own long-term benefits in the form of post-working life security? So, very valid question, Mr. Mukesh. I will answer this while relating to my own past experience. So, as a young employee, when I joined the industry, so I withdrew my PF after first 5.5 years of service after leaving that group, and then also withdrew the PF from my second organization. So this I utilized for cash down payment for my first car, Maruti 800 in 2003, and then for booking my house, a flat, way back around 2005. So for down payment of that. So I utilized all my PF amount because I had no other savings or lump sum thing as a younger employee to bank upon to use for such kind of needs. However, after around 10 years of service into the industry, I then never withdrew my PF and I always transferred it. So awareness was also not there that it can be transferred. People used to say you can withdraw it after 60 days and like that. So yes, financial planning awareness session sort of thing will be helpful for all your employees and they will be thankful to you. We have conducted some of it in our past organizations and people thank it always because awareness is not there. So employees are not able to plan short term, long term judiciously. And the principle of compounding, I think you will be knowing well. That's why you have asked this question, that it works well when you start early. However, in hand, immediate needs are to be catered for bachelors, then marriage, then your child, then education, home, car, etc., etc. So yes, initial years for any mid-class employee is of a struggle. So this balancing has to be done to take care of what is needed by employees in different age groups. And yes, awareness helps. Definitely, that will be a service from employer and HR. Mr. More Mukut Singh is asking, as HR, do we need to have basic plus DA as 50% of CTC for employees with CTC above 5 lakhs? So, Nirmalji, will you like to take this question?
Yes, it is so. It is so because the wages, the definition of wages covers all employees. So yes, it is so.
So, just to answer your question a little more comprehensively, wages restructuring in line with this 50% requirement will have to be done for all classes of employees, all kind of CTCs. Coming to second point, can PF be deducted lesser for certain employees if they wish so? So that will need HR innovation and HR transition in different contexts as of now. How much administrative service they will like to do for the employees to safeguard their interest uh, at the cost of their own complexities and using digital systems. But various possibilities are there. Legally, you can have this compliance 50% of CTC, yet you can protect the in-hand salaries of the employees and you can utilize the transition period. So more on this we can suggest on one-to-one basis only. Another question from Mr. Mukesh. I suppose there is a need for doing this education along the principles of uh, mutual fund sahi hai like initiatives. Absolutely bang on. Yes, if there can be some kind of initiative like this by companies or larger industry forums, so that will be highly beneficial for the employees and even for HR and employers. So we encourage that, and in fact, with this spirit only, we have organized this free live session so that all the stakeholders can benefit. Today is 21st December, so approximately 1 month after the codes were released officially, they were formed long back, even before COVID also. So yes, we will also conduct such sessions if we feel a need further. And yes, there is a need for such kind of initiative. Very innovative thought.
Very innovative.
Yeah. So, uh, so I guess we have come to the close of this live session. And thank you for being part of this session. You have been a wonderful audience. Thank you for your patience, for your time, for your enthusiastic queries.
And for your intelligent questions.
For your intelligent questions, because they also help us develop our problem solving abilities. And it was really wonderful having all of you here and for your time on this late morning of Sunday, 21st December. And we'll be happy to assist you or your organizations in whatever capacities in case you want. We have given our contacts in the chat already, and it's available on our website also, nexthumanorbit.com, and on the social media handles also. So thank you. And with this, we say a good boy and have a nice day. Have a nice Sunday. Enjoy yourself and happy implementation.
Thank you. You have been a very nice audience, and we have enjoyed this hosting this show as much as you have been interested in asking the questions.
Yeah. Thank you. Bye bye.
Thank you.